Good afternoon, ladies and gentlemen. We're ready to hear argument in the case of Carina Ventures against Pilgrim's Pride. Mr. Ho.
Judge Easterbrook, and may it please the court. The district court should not have granted summary judgment because there is plenty of evidence that both parties were negotiating in stages, understanding that they would be bound only by signed agreement, and that Barrett Flynn's "we accept" email merely expressed agreement in principle on one term in the first stage of negotiations. The legal standard here is settled under Abbott Labs against Alpha Therapeutic and Ocean Atlantic Development. Pilgrims must show that the parties' words show a clear intent to be bound to a preliminary agreement. 5 points create, at the very least, a fact issue. 1, commercial expectations. 2, the parties' email correspondence. 3, the terms of the parties' drafts. 4, Pilgrim's conduct inconsistent with the existence of an agreement. And 5, the terms of the judgment sharing agreement. First, this was a large, complex, multi-case settlement, the kind that sophisticated commercial parties consummate by signing agreements, not by emails between counsel. As this court said in Abbott Labs, the magnitude of a deal requires careful scrutiny of any claim that informal letters in the course of freewheeling settlement negotiations constitute a binding agreement, and that's just so here. Second, both parties said repeatedly in emails that a written agreement was required, and I direct the court specifically to ECF 7438, especially Exhibits 3 and 9. Exhibit 3 is the first offer that Pilgrims ever made to Cisco, and it said that that offer was, quote, contingent on a full settlement and release of all claims related to the broilers antitrust, including release of Pilgrim's share of liability under the judgment sharing agreement. Contingent on. That is the magic words that this court has said is the clincher for communicating that an agreement is only going to be consummated through a signed written document. And when Mr. Flynn proposed a counter, he said that the demand contemplates confidentiality and a full and final settlement release to be drafted in the coming weeks. So both parties said from the beginning of their negotiations that this agreement would only be consummated through an executed written document consistent with the commercial expectations of parties in this situation. Third, when they got to actually drafting those agreements, there was an integration clause starting with the first drafts that were exchanged on October 7th. Those drafts contained provisions that said that there would be execution, that there was no binding agreement until there was execution, and it even went so far as to forbid the parties from claiming that there were enforceable terms based on anything that occurred prior to execution. Fourth, when Pilgrims could not get Cisco to sign because it was enjoined from signing, Pilgrims didn't say Cisco had already settled. What did it do? First, it continued to negotiate and tried to get Cisco to sign. When that didn't work, it threatened to walk away from the agreement. That's Exhibit 42, paragraph 59. And then, when that didn't work, when the threat of walking away didn't get Cisco to sign the agreement, it continued to litigate, including a failed summary judgment in broilers and a failed motion to dismiss in pork. If Pilgrims had won those motions, it would not be here today asking this court to allow it to pay the amount to Cisco that it thinks that it settled for.
Mr. Ho, on the continued litigation point, could you explain to us where plaintiff Cisco at that point fit in the track 1 and track 2 arrangements in the district court, and because the defense is telling us we litigated in track 1, but you were in track 2.
So That argument applies, first of all, only to the broiler chicken case, and there were two motions that were filed. One was in pork and one was in broilers. But as to broilers, it is...
Mr. Ho, Judge Hamilton is not actually in that screen. If you want to face it, the camera is right in front of you.
Okay, thank you. That's helpful clarification. I appreciate
That's a little
that.
more direct, thank you, yes.
To your question, Judge Hamilton, and now that you can hopefully see me a little more clearly, it is true as a technical matter that Cisco had elected to be a Track 2 plaintiff, and that the summary judgment motion was filed in Track 1. But as a substantive matter, the claims in Track 2 are essentially very similar to the claims in Track 1. The claims in Track 1 are a subset of the claims in Track 2. And so the reason that the conduct is inconsistent is that everybody knew that if the motion for summary judgment in Track 1 were granted, that would have a dramatic impact on the value of any claims in Track 2. And so by pursuing litigation, even while it said that it thought there was a settlement, and then only waiting to see how the litigation panned out, what Pilgrims did was essentially give itself the option whether it wanted to enforce the agreement after it figured out whether it had won or lost.
At the risk of putting words in your mouth, would it be fair to say that if Pilgrims had prevailed in their Track 1 motion for summary judgment in the broilers case, that would have had a pretty dramatic effect, reducing the value of the pending claims in the Track 2 litigation?
Absolutely. And conversely, the fact that the motion was denied had the effect of increasing the value.
Could I ask you a couple of other quick questions?
Of course.
One is, given the overall status of the MDL, if we were to disagree with the district court here, would that have effects on other settlements in the larger MDL?
Well, not in the broiler chicken MDL. It might cause the District of Minnesota, in which Pilgrims also filed motions for summary judgment, to reconsider what it has done. The district court in Minnesota invited Cisco to file a supplemental brief if, in fact, this court reverses the district court in this case. So that would be the potential follow-on effect. But that's limited to the settlement before us, not to any settlement involving other parties.
Yeah. If I could also ask one other question. We see a lot of disputed settlements in much simpler cases where somebody has buyer's remorse either before or after a final settlement agreement is reached, but often after money has changed hands. And very often a plaintiff's willingness or ability to return money winds up being critical in that question. As I understand it, you all received, or rather Cisco received and then passed on to you all money in the summer of 24. Is that correct?
Correct.
And what effect should that have on our deliberations in this case?
None, Your Honor. We made very clear that we didn't want that money. In fact, what Pilgrims first tried to do is ask us for wiring instructions, because under the draft settlement agreement that they now claim is enforceable, they were supposed to wire us money. And we said, we're not going to give you the wiring instructions because we don't want the money. We don't think that there's an enforceable agreement. At that point, they sent 3 checks to Cisco's Denver office. And what Cisco did at that point was follow the law. They did cash the checks, or deposit the checks more accurately, but they did so making very, very clear that this was not meant to constitute ratification of the settlement. That money is ready to be returned the moment Judge Durkin's order is reversed. And so, in our view, it has no effect on the outcome of this appeal.
I think I interrupted you before you got to your 5th point about the JSA. Mm-hmm.
Yes, the 5th point is about the JSA. And the JSA, the terms of which are in black and white Section 6 says that a qualified settlement has to be in writing. And Pilgrims conceded below, concedes here, that it was not willing to settle without a qualified settlement. So that is yet further evidence that Pilgrims understood, and that the parties understood, that there would be no binding agreement unless there was an executed written settlement agreement. To put it differently, if what happened in September of 2022 were deemed to be a binding agreement, it wouldn't qualify under the JSA, under the judgment sharing agreement. And that's concededly not what Pilgrims wants, and not something that Pilgrims would accept. Judge Hamilton, as you say, there may be lots of settlements in smaller cases that are resolved through oral agreements and that can be enforced without a written executed document. This is not one of those because of the magnitude of the agreement, because of the parties' mutual understanding that only a binding settlement agreement would do. If there are no more questions at the moment, I will reserve the rest of my time for rebuttal.
Certainly, Mr. Ho.
Thank you.
Mr. Michel.
Thank you, Your Honor, and may it please the Court. Chris Michel for Appellee Pilgrim's Pride. This is a case of black letter contract formation. Following detailed negotiations, Pilgrims made a settlement offer to Cisco. Cisco responded, "We accept." That creates an enforceable agreement between the parties, and as the district court found, the objective evidence leaves no doubt about that agreement's terms. The only dispute here comes from a non-party litigation funder seeking to collaterally attack the settlement so that it can try to negotiate better terms. But as this court has consistently explained, buyer's remorse, especially by a non-party, is not a valid basis to escape a binding contract. This court
Michel, in terms of just commercial expectations in the context of these negotiations, can you point us to comparable cases, comparable complexity, where courts have managed to piece together a binding agreement, as you're arguing should be done here?
A couple of responses to that, Judge Hamilton. First, I think that this case is actually, the agreement here is not actually as complicated as my friends might portray it to be. This is, as was discussed with Your Honor in the top half of the argument, one relatively discrete and small piece of a large consolidated matter before Judge Durkin and then an MDL.
Let's assume, bear with me and assume that since you've got three cases, $50 million, effects on other parties through both allocation issues and these questions of assignments, and your JSA requirements, the most favored nation clause, and so on. Let's point me to something that is comparably complex and of similar magnitude or larger that has been resolved without what most of us would recognize as a binding, integrated, executed agreement.
Sure. I think the Quake case from the Illinois Supreme Court that's cited in the briefs is one example. That's Quake Construction versus American Airlines. And in that case, I don't know that the dollar value was exactly the same as this, but it was two big businesses. My friend referred to the Abbott Labs case. It was called Abbott Labs versus Alpha. That's a case between two large businesses. It was about Alpha acquiring the blood products division of Abbott, a complicated arrangement by any measure. And it's true that at the end of the day, this court concluded that there was not a binding settlement in that case. But this court made very clear that nothing would preclude a binding settlement through informal means if the parties had actually agreed to that. So there's no sort of carve-out, Your Honor.
Would you agree that commercial settings and magnitude in Illinois law are relevant factors?
I think there's nothing wrong with considering it a relevant factor, but I'd respectfully submit another relevant factor is that this is a settlement agreement. I think most of the other, in other words, an agreement whose purpose is to terminate the litigation and to essentially have no further relation between the parties. I think many of the cases my friend has pointed to are cases about complex, ongoing commercial relationships. That was the case, for example, in the BFT Roberson case about an ongoing truck maintenance and supply contract. The Ocean Atlantic case is also about a complex property purchase. So I'd submit the relevant question is not necessarily how complex the commercial relationship is overall, but how complex the actual deal is. And in this case, it's a pretty straightforward deal to dismiss claims in return for money and compliance with these two familiar contractual provisions.
And the assignment and allocation issues being worked out. Could I ask you, the standard of review is being debated here, and our precedents allow quotations of a rather confusing mishmash of different standards of review. Let me just offer a perspective on what we have here. Without it having been formally pled, what we have in substance is an affirmative defense of accord and satisfaction and summary judgment having been granted on that basis. Does that make sense to you?
I think that is one way to look at it, but I also think, and I appreciate your Honor's point about this court's cases, I do think the cases that analyze this question describe it in terms of a district court's inherent supervisory authority over litigation to enforce a settlement, and that's what triggers the deferential standard of review. And that is, I will submit,
usually that's because the judge is in effect a witness to the settlement. But, okay. One other question that I wanted to raise with you, if I could, is whether if we were to disagree with the district judge's analysis here, is there any disputed issue of fact from your perspective that would require a finder of fact to consider this issue of the validity of the settlement?
Well, I suppose it would depend on how exactly you disagreed with Judge Durkin. Obviously, our position below was that there's not a disputed issue of fact.
I understand that. That's why I'm asking you this question.
Right. I think if you found that he had abused his discretion or it was unreasonable for him to enforce the contract because there were still genuine disputes, then yes, we would, I think, want the opportunity to dispute those issues. Of course, we're here.
Dispute what? To dispute whether, for example, the proportion of assignments or the allocation among the different cases were material issues, since, as I understand it, those would have affected most favored nation clauses involving many parties and the value of the settlement to you all.
Right. Well, I think the principal dispute, at least the one my friends have identified in asking for a reversal here, is what were the material terms of the agreement that the parties agreed to.
Let's talk for a second about allocations.
Yep.
Right. The allocation, as I understand it, among the three different cases would affect this so-called, is it the value ratio? Is that the right term for the settlement?
I think you might be.
Something.
There's three concepts that are related as your question gets to. There's the most favored nation provision that I think the assignments, may be what Your Honor is alluding to. The assignments affect the ratio.
I'm starting with the allocations. Right. I'll be happy to hear what you have to say about the assignments too.
Yep. So the way those relate to each other is once you calculate the most favored nation ratio, then you can determine the allocation to the broiler settlement. And once you determine the allocation to the broiler settlement, you can determine the allocation to the beef and pork settlements, given the $50 million total figure.
Right. And the way those numbers work out is pretty important, isn't it?
It definitely is pretty important, but it's also pretty mechanical, we'd respectfully submit, after the parties have agreed to the terms. It's basically applying a formula, as you suggested. There's a ratio that is applied to the volume of commerce, and it's just a mechanical calculation. An important one, but one that I think everyone agrees on what it is and how it can be performed.
And so let's talk about the assignments for a moment. the as I understand it, until fairly late in the fall of 2022, it was unclear, at least to your client, just how many Cisco potential claims had been assigned to other entities. Is that right?
I think it's true that we didn't know the exact number.
And presumably it would have been material whether the number amounted to 1% or 10% or 50% of the potential claims, right?
With respect, I think quite the opposite. The fact that my client was willing to make this deal indicates that it was not material to them, and the parties understood that whatever the number was, it was going to be a relatively small and a relatively straightforward number. So they were willing to.
Bear with me for just a moment, though, because as I understand it, this was an unknown. Your client says we're willing to pay $50 million if the assignments had covered 50% of the potential Cisco claims. That would presumably kick the value ratio up substantially, right?
I think that's right. And
triggering MFN clauses with settlements with other plaintiffs in the broiler case.
In that hypothetical, yes, of course, that's not what happened, and we, I think, had a good understanding of what the range was likely to be, and were therefore willing to bear that risk in entering into this settlement.
And where do we see that, the objective evidence of your willingness to bear that risk? Because what I saw was pretty consistent reservations about having to do with assignments.
With respect, Your Honor, I think all the communications show is that we recognized we needed to get the assignments so that we could run the formula. And I don't think there's any dispute among the parties that the MFN was an included term, and that even though there's obviously a dispute about the $50 million, about whether there was a settlement, as my friend for the other side said, they have the $50 million. Nobody's disputing that that's the right number, and nobody's really disputing anything about how the assignments worked out. So I think the best reading of the record is simply that the parties recognized that was going to be a mechanical calculation that would follow.
From your perspective, as of what moment was there a binding agreement?
I think that we accept email on September 9th is what completed the binding agreement. It was against the backdrop of the prior negotiations for sure, but that was the moment when the contract was formed.
Thank you.
Just a few other points that I might follow up on. There was some discussion, Judge Hamilton, about the other tracks of the litigation. We go through this in around page 37 of our brief. It's a bit complicated, but the short version.
I think we've got that. I think we understand that. Could I ask you to address the issue of the I'm sorry to use the acronym, but the JSA.
Yep.
And so as I look at those terms, it certainly looks like you need a signed written agreement that you can provide to the other defendants and have to do so within 7 days of reaching the agreement. Is that right?
So I'm not sure the JSA is all that clear on that point. That's certainly what my friends submit, but I'd also say that's not... Well, that's not an issue really before this court. That would be an issue about between the parties to the JSA. I think Your Honor recognizes.
Well, it's not hard to imagine this case turned upside down, right? With summary judgment granted, motion to dismiss granted in the Port case, Cisco and Karina come to you and say, we want our $50 million after those decisions, and you say, we're not even close to a final agreement here. We insisted that the JSA be complied with, and we don't have a document that's signed that we can send to our fellow defendants.
Well, I have to say, I think our response in that position would be that we do have a binding settlement. We couldn't get out of the $50 million. I think if we had tried to get out of the $50 million, Cisco would not have let us do that. And I think... Well,
we can't be having these same debates with the opposite side being taken.
We would.
But help me out. with the requirements and expectations of the joint defense agreement.
Right. So if there's one thing that's clear in this case, it's that Cisco knew about the joint settlement, the JSA, the judgment sharing agreement. That's because they had challenged it in a case that came to this court. As we explained in the brief, there are communications from Cisco saying that the parties in this case are not settling, the defendants in this case are not settling without the JSA. So they recognized that that was a necessary term. And on page 16 of their brief, they point out that it was removed at one point in the back and forth between the parties about the ultimate agreement. But if you look at the underlying citation for that, when it's reinserted, there's a comment that says the parties agreed on the JSA provision. And that's the end of it. The final agreement that Cisco sends back to Pilgrims includes the JSA provision. So I take the point that there could be future disputes among the defendants or among the defendants in the broader litigation and Cisco potentially about whether the JSA was satisfied in this case, but that's a different question than whether the parties agreed to have a JSA provision in their agreement. And that's a question that would have to be answered if it arises in future litigation in a different case.
So what would the argument be that this settlement qualifies as a sufficient settlement to trigger rights and obligations under the JSA?
Well, the argument would be that knowing
within the terms of paragraph or section 6A.
Right. That of course would have to be the subject of separate litigation, but I would imagine the argument would be that Cisco knew exactly what the JSA term was, and it would be the argument we're making in this case, that they agreed to the settlement with that term incorporated, and therefore it satisfies the JSA. We would probably also point to the ultimate document that does have the JSA provision in it.
Which was not signed. But that's and that would be your fellow defendants might potentially be trying to argue that they are still entitled to the benefit of that because that was intended, even though you failed to comply with it.
They might. I think might is the right conditional framing, because it would require an ultimate judgment of liability in the case, and it would require other decisions of the kind you've alluded to.
That's what that agreement is for, right?
It is, and I'm not going to try to litigate that case today, except to say that the parties agreed here that their settlement would comply with the JSA, and that's all this court needs to decide, as Judge Durkin did.
Thank you,
Thank you,
Mr.
Your Honor.
Michel. Anything further, Mr. Hull?
Briefly, Your Honor. On the judgment sharing agreement, I would just point out that Pilgrims never sent the September 9th email exchange to any of their judgment sharing agreement co-defendants. If they really thought that there was an agreement at that time and that it qualified under the judgment sharing agreement, they would have tried to satisfy the obligations that they have under the judgment sharing agreement. So I think that, again, the conduct of Pilgrims is completely inconsistent with the existence of an agreement. The bottom line answer on the September 9th email exchange is that it wasn't a definitive offer because it didn't include resolution of 4 important terms that we have discussed at length in our brief, and it was not an unconditional acceptance. Mr. Flynn said, "We accept," but he right away said, "And could you please get our outside counsel together so they can work on the releases?" And Judge Hamilton, just on the question of whether there is a factual dispute, honestly, we don't think that on this record there is a factual dispute. We think that the facts make very clear, the undisputed facts make very clear, there was no binding agreement. We didn't move for summary judgment below, but I am not aware of any evidence that Pilgrims has left on the cutting room floor. So if there is some factual dispute, it must be based on something that is not in this record. Unless there are further questions, thank you very much.
Thank you, Mr. Ho. Thanks to both counsel. The case is taken under advisement and the court will be in recess.